South Carolina's 5 male Supreme Court justices hold the fate of abortion access in our state in their hands.
Justices heard arguments today in a challenge to a new 6-week ban after they struck down a similar law in January. State House reporter Mary Green was in the courtroom and has details.
Tuesday's proceedings lasted just over an hour at the state Supreme Court, with no timeline now for justices to deliver their decision. A central question is if this new law is different enough from the one the court ruled unconstitutional in January to warrant a different outcome this time. Attorneys for South Carolina abortion providers argue this new law, which Governor Henry McMaster signed last month and which a court blocked from being enforced the next day, is functionally the same as what justices ruled unconstitutional 5 months ago. It bans most abortions after fetal cardiac activity is detected, typically around 6 weeks into a pregnancy, and allows for limited exceptions to save the mother's life in cases involving sexual assault victims and in cases of fatal fetal anomalies.
Women can know they are pregnant in that time, but that we also know as a matter of statistics and evidence that they do know that they are pregnant in that time.
Where is this evidence? We keep talking about the evidence. There's not one shred of evidence submitted in this record.
There is a distinction, I think, legally between do women know and can women know?
There are many factors to consider beyond just whether someone has the ability to recognize that they're pregnant.
Attorneys for abortion providers argue this law violates the state's constitutional right to privacy, the basis on which the previous law was struck down in a 3-2 decision.
My clients are back here today because the General Assembly ignored this court's ruling, enacted a virtually identical law, Senate Bill 474, which also bans abortion at 6 weeks.
One opinion from this court is not enough to trigger binding precedent.
Attorneys for the state say the Republican-controlled legislature made language changes to the bill to address concerns justices raised in their previous ruling, particularly Justice John Cannon Few.
There is a very good argument that the January decision is not precedential and is not binding.
Another key difference hanging over Tuesday's proceedings is that the South Carolina Supreme Court no longer has a woman on the bench as it did last time. Until the Supreme Court or another state court rules otherwise, abortion is legal in South Carolina before about 20 weeks into a pregnancy. Reporting in Columbia, I'm Mary Green.